served as member secretary to Tamil Nadu State Legal Service Authority at Chennai, where he has introduced very many novel ideas to promote the importance of Lok Adalat. His innovative steps towards Lok Adalat has picked up momentum in Tamil Nadu, and his services towards the same has tremendous appreciations. Therefore, I think we are fortunate to have this lecture on the given topic from an expert. With this small note, I welcome our speaker, Dr. Justice T. Madhivanan, to enlighten us on the topic. Over to the speaker.
Okay. My respected and beloved legal fraternities, good evening to you all. I'm immensely pleased to meet you all through this Zoom meeting. Necessarily, I have to extend my gratitude and thanks to our brother Om Prakash and Mr. K. Murthy. They only invited me to speak on this subject called Permanent Lok Adalat vis-à-vis Lok Adalat practice and procedure. This is very important subject which is in need of this hour, because in most of our legal fraternity in rural areas, they do not know what is Lok Adalat and even how to pronounce Lok Adalat. You understand? Even we conducted several programs all over across the country through the National Legal Services Authority and through the State Legal Services Authority and even through the Taluk Legal Services Committee. The programs are still yet to reach the people who are living in and around that area. Here, the legal services, not only in our country, is spread over across the world. Even I have also written an article in the, it is available in the net as well as in the Tamil Nadu Judicial Academy book with respect to the legal services. And here, the Legal Services Authorities Act 1987 was enacted to constitute legal services authorities to provide free and competent legal services to the weaker sections of the society, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic and other disabilities, and to organize Lok Adalat to secure that the operation of the legal system promotes justice on a basis of equal opportunity. Because the Article 39 capital A provides justice shall be made available to the doorsteps of the people in need. That is the main motto of this organization. In order to achieve the object as mandated under Article 39 capital A of the Constitution of India, the central government had by resolution dated 20th September 1980 appointed a committee for implementing legal aid programs under the chairmanship of Honorable Mr. Justice P.N. Bhagavati, as he then was in Supreme Court, and to monitor and implement legal and programs on a uniform basis in all these states. You understand? And union territories. The committees were appointed in all the states and union territories evolved a model scheme for legal aid programs. Subsequently, on a review of the working of the committee, certain deficiencies were noticed, and it was thought to constitute a statutory legal services authority at the national level as well as at the state and district levels, so as to provide for an effective monitoring of legal and legal aid programs. This is an introduction to our program today, and in consonance with the title of this webinar, we have to analyze and discuss about the practice before the Lok Adalat as well as before the permanent Lok Adalat and their nature of functioning to render free legal services to the needy people. The phraseology Lok Adalat connotes the meaning People's Court. Lok stands for people and Adalat stands for court. It is therefore clear that this statutory institution has been established with the prime intention of assisting the courts in diluting the pendency of the cases and to provide equal justice to the poor and needy people at their doorsteps, irrespective of caste, creed, religion, and without seeing any discrimination between the subjects of this nation. And further, the this scheme has been evolved to provide free legal aid at any cost. No amount is being collected from the public, but instead, all the assistance to the people have to be rendered without even paying a single rupee, even if any case is referred to the local adalat and settled at the instance of the presiding judges and other members. After its settlement, the court fee, which was paid already by the parties to the cases, have to be refunded. This is the most important thing. And secondly, the Lok Adalat is having statutory status. The Legal Service Authorities Act in 1987, and therefore it is considered to be one of the alternative dispute resolution mechanism, ADR mechanism, not only in India but also in the whole world. Resolving disputes through Lok Adalat not only minimize the litigation expenses, because it also saves the time of both the parties. The adalats are generally organized in the premises of courts. It can be said that Lok Adalats are people's festival of justice because settlements are not always necessarily according to legal principles. The Legal Services Authorities Act 1987 having an important chapter, that is chapter 6, it contemplates Lok Adalats and it encompasses sections 19 to 22. Lok Adalats, it defines. Section 19 deals with organization of Lok Adalat, whereas section 20 deals with the organization of cases by Lok Adalat. Section 21 deals with award of Lok Adalat, whereas section 22 deals with powers of Lok Adalat. In accordance with section 19 of the Legal Services Authorities Act, the following authorities can organize Lok Adalat. Please see, according to section 19, the State Legal Services Authority, then the District Legal Services Authority, Supreme Court Legal Services Committee, High Court Legal Services Committee, and Taluk Legal Services Committee can have competency to organize Lok Adalat. Then every Lok Adalat which is being organized by the above said authorities shall consist of a serving or retired judicial officers and other persons. Here you have to see, as per subsection 3 of section 19, the experience and qualifications of other persons rather than the judicial officers, either retired or serving for the Lok Adalat organized by the Supreme Court Legal Services Committee shall be such as may be prescribed by the central government in consultation with the Chief Justice of India. Then, subsection 4 of section 19 envisages the experience and qualifications of other persons excepting the judicial officers shall be such as may be prescribed by the state government in consultation with the Chief Justice of respective high courts of the state. This is an interlude with regard to organization of Lok Adalat, how the Lok Adalats are being organized by central authority, that is National Legal Services Authority or the state legal services authorities. Thirdly, the Lok Adalat, as seen from subsection 5 of section 90, shall have jurisdiction to determine and arrive at a compromise or settlement between the parties to a dispute in respect of, number one, any case pending before the courts. The Lok Adalats can be organized in respect of any course pending before the courts, or otherwise any matter which is falling within the jurisdiction of the Lok Adalat and it is not brought before any court for which Lok Adalat is being organized. These two points are very much important. The Lok Adalats can be organized in respect of matters pending before the court or in respect of the matters which are not actually brought before the court can also be brought before the Lok Adalat, provided the Lok Adalat shall have jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. Example, I will tell you an example. All compoundable criminal cases can be brought before Lok Adalat, but non-compoundable criminal cases cannot be brought before the Lok Adalat. However, in my experience, I can tell you, one time during the year 2009, I think so, a rape case was brought before the Lok Adalat. The victim as well as the accused were present. One honorable justice, as he then was, he was presiding over the Lok Adalat. See, you remember, the section 376 is non-compoundable offence that cannot be settled before the Lok Adalat. What the honorable judge suggested was that the victim has agreed to get the case compromised and the accused also agreed to get her married. Therefore, both the parties, both the victim and the accused have agreed to marry each other. Under this circumstance, what is the purpose he is going there? What purpose is there in allowing the matter to go for full trial? When the matter is settled and the parties are agreed to marry with each other, that what is the necessity of allowing the parties to the case to suffer the harassment attending each and every court? Because the sessions case, it will take some time. Therefore, when the matters are settled, the judge suggested that when the ultimate result is feeble or the bleak in conviction, then why this matter cannot be settled. However, it is against the principles of that section 90. You understand? Section 90 says the Lok Adalat cannot take cognizance of the criminal cases which are non-compoundable. When both parties are settled, this is rarest of rare cases. Under such circumstances, the judge suggested no matter, the settlement can be recorded and may be referred to the Honorable Chief Justice. Let him decide. This is for example. Then, the cognizance of the cases by Lok Adalats, under what circumstances the cases pending before a court can be referred. Then the parties must be known that how the pending cases before a court of law can be referred to the Lok Adalat. As seen from section 16 of the Adalat Act, the parties thereof agree. When a case is pending before a court, when both parties agreed, no matter that matter may be referred to the Lok Adalat, and we can settle the matter there itself. The presiding officer, the judicial officer who is presiding over that case, can refer the matter to the Lok Adalat. This is one thing. The other thing is, one of the parties thereof makes an application to the court for referring the case to the Lok Adalat for settlement. And if such court is prima facie satisfied that there are chances of such settlement, he can refer the matter. The third one is, if the court is satisfied that the matter is an appropriate one to be taken cognizance of by the Lok Adalat, it can be referred to the Lok Adalat, provided, as I have already told you, no case shall be referred to Lok Adalat under subclass B of class 1 of class 2 by such court, except after giving a reasonable opportunity of being heard to the parties. Unless the parties are heard, unless the parties are giving consent to refer the matter, that cannot be referred to the Lok Adalat. Even one party has not agreed the matter to be referred to the Lok Adalat, the court must be very slow in referring the matter to the Lok Adalat. Then the authority or committee which is organizing the Lok Adalat under subsection 1 of section 19 may, on receipt of an application from any one of the parties to any matter referred to in clause 2 of subsection 5 of section 19, refer such a matter to Lok Adalat for determination, provided such a matter needs to be determined by Lok Adalat. But that is the main thing. The prima facie, whether that matter needs to be determined by the Lok Adalat, the judge who is presiding over the court can refer the matter to the Lok Adalat. Where no award is made by the Lok Adalat, when no settlement is effected, on the ground that no compromise or settlement could be arrived at between the parties, the record of the case shall be returned by it to the court from which the reference has been received under subsection 1 for disposal in accordance with the law, with an advice to the parties to seek appropriate remedy in the court. See, one of the benevolent and beneficiary provision is section 21. Section 21 of Legal Services Authorities Act 1987 is a crucial section which contemplates award of Lok Adalat. According to this section, every award of Lok Adalat shall be deemed to be a decree of civil court, or, as the case may be, an order of any other court, and where a compromise or settlement has been arrived at. Where a compromise or settlement has been arrived at by a Lok Adalat in a case referred to it under subsection 1 of section 20, the court fee paid in such cases shall be refunded, which I have told you already at the initial stage. Refunded in the manner provided under Court Fees Act 1870. It is important to note that every award made by Lok Adalat shall be final and binding on all the parties to the dispute, and no appeal shall lie. This is the word to be underlined. There is no appeal against an award passed by the Lok Adalat, which is the final. Number one, and one man has asked a question. Sir, even after passing an award, if any correction or any dispute is there, how it could be challenged? Because as per section 21, no appeal shall lie against an award which is final, which is considered to be a decree passed by a civil court. When such being the case, supposing if any strong dispute is arisen, and how that matter could be challenged, the only way is there, already decided cases are there. The party has to approach to the High Court by way of writ. The discretion of the High Court can be exercised. The extra jurisdiction, civil jurisdiction can be exercised. When the matter is deserved to be appealed, challenged, that can be challenged through a writ petition only. And now I can speak over the powers of Lok Adalat. What is the power conferred on the Lok Adalat? Section 22, with reference to powers of Lok Adalat, Section 22A and Section 22B, with reference to establishment of permanent Lok Adalat, have been inserted and substituted to Legal Services Authorities Act 1987 by the Legal Services Authorities Amendment Act 2002, Act 37 of 2002. The Lok Adalat or permanent Lok Adalat shall, for the purposes of holding any determination under this Act, have the same powers. The Lok Adalat as well as the permanent Lok Adalat, for the purpose of arriving at any determination, shall have the same powers as are vested in a civil court under the Code of Civil Procedure 1908, while trying a suit in respect of the following matters, namely, in respect of summoning the parties and enforcing the attendance of any witness and examining him on oath. Then the discovery and production of any document, the reception of any evidence or affidavits, the requisitioning of any public record or document or copy of such record or document from any court or office, and such other matters as may be prescribed. Therefore, the powers of Lok Adalat or permanent Lok Adalat is equivalent to the procedure adopted by the civil court under the Code of Civil Procedure. All proceedings before a Lok Adalat or permanent Lok Adalat shall be deemed to be judicial proceedings. You must understand this. Within the meaning of section 193, 290 and 228 of the Indian Penal Code, and every Lok Adalat or permanent Lok Adalat shall be deemed to be civil court for the purposes of this the section 195 and chapter 26 of the Code of Criminal Procedure. Understand? Then, what are the types of cases can be brought before the Lok Adalat? The cases with reference to mutation of land records, then compoundable criminal cases, the encroachment on forest land, the cases relating to family disputes, and the cases relating to land acquisition disputes, the motor accidents claims petitions, cases which are not sub judice. These are the cases can be referred to Lok Adalat. Then the features of Lok Adalat are, what are the important features are, as already spoken to you, no court fee is required to pay when a matter is filed in a Lok Adalat. It provides speedy trial for every dispute. Its award is final and binding on both the parties. No appeal will lie against an award. Both the parties can directly interact with the judge, which is not possible in regular courts. Is it possible in regular courts? Can a party interact with the judges? But on the other hand, in Lok Adalat, they can be free interacting with the presiding officer. Both these parties, the proceedings are very easy and simple and costless, penniless. That is called People's Court, Lok Adalat. Then next, we come to permanent Lok Adalat. How the permanent Lok Adalat is being established. That is in respect of pre-litigation, conciliation and settlement. You know what is pre-litigation? The matter in respect of the matters which are not brought before the actual court of law. Even without filing any single paper before a functional court, you can bring all the settled matters even pre-litigation time. That is the pre-litigative method. The pre-litigation and conciliation are very much important in respect of public utility services. Then the central authority, or as the case may be, every state authority shall, by notification, establish permanent Lok Adalat at such places and for exercising such jurisdiction in respect of one or more public utility services and for such areas as may be specified in the notification. Then I will tell you what are all the public utility services later. A permanent Lok Adalat is a civil court that has been set up under the Legal Services Authorities Act. It composed of a chairperson who is serving or retired district or session judge or a judicial officer higher in the rank and two other members who performed general judicial services. Though the permanent Lok Adalat is considered to be a civil court, in fact, I tell you that it is not bound by the Civil Procedure Code 1908 and the Indian Evidence Act 1872, having the power to devise its own procedure. The permanent Lok Adalat is having power to devise its own procedure. A permanent Lok Adalat may summon a person or document among other evidences. The pecuniary jurisdiction of because each and every court is having pecuniary jurisdiction. Without adhering to the principles of pecuniary jurisdiction, no matter can be brought before any court of law. Likewise, the permanent Lok Adalat is also having pecuniary jurisdiction up to ₹1 crore. In cases that have no direct monetary connection, the permanent Lok Adalat can pause any order within the orbit of any statutory or constitutional mandate. That such type of power is vested with the permanent Lok Adalat. The system has been set up nationwide in places such as Uttar Pradesh. Here all the permanent Lok Adalat has already been constituted in such places like Uttar Pradesh, Delhi, Haryana, Kerala, Tamil Nadu. In Tamil Nadu exclusively, when I was the member secretary here, State Legal Service Authority, based on the principle followed by the Andhra Pradesh, I wrote to the state government to set up a permanent Lok Adalat here. Only in pursuant to my letter to the Tamil Nadu government, here in consultation with our Honorable Chief Justice here, the permanent Lok Adalat was set up in certain areas of our Tamil Nadu. In the year 2002, the Union Parliament had amended the Legal Services Authorities Act to provide for setting up the permanent Lok Adalat under Article 323 capital A and 323 capital B of the Indian Constitution. These articles provides for tribunals. Article 323 capital A deals with the administrative tribunals, whereas Article 323B deals with the tribunals for other matters. As per Section 22(3) of Legal Services Authorities Act, All proceedings before a permanent Lok Adalat shall be deemed to be judicial proceeding, which I have told you already. In permanent Lok Adalat, even if the parties fail to reach to a settlement, the permanent Lok Adalat gets jurisdiction to decide the dispute, provided the dispute does not relate to any offense. Because the permanent Lok Adalat doesn't have power to deal with any criminal cases. Because it is considered to be a civil court. However, it is not bound by the Civil Procedure Code 1908. Further, the award of the permanent Lok Adalat is final and binding on all the parties. The permanent Lok Adalat may conduct the proceedings such as a manner as it considers appropriate, taking into account of the circumstances of the case, wishes of the parties, like a request to hear oral statements, speedy settlements of dispute, etc. It can devise its own procedure to settle the matter expeditiously. Apart from permanent Lok Adalat, national Lok Adalat, the Mumbai Lok Adalats are also being organized in various parts of country, which travel from one location to another location so as to bring the justice at the doorsteps of the needy people. As stated in the foregoing paragraphs, the permanent Lok Adalat can exercise its jurisdiction in respect of one or more public utility services. What are they, and for such areas as may be specified in the notification. Now I can tell you the what are the public utility services. The main features of public utility services are to make it understandable. The list of various industries which are declared to be the public utility services under subclass 6 of class N, section 2, which includes transport other than the railways, because it is having separate tribunal. Transport for carriage of passengers or goods by land or water. Then banking matters. Then the cement manufacturing industries. Then the coal. Then cotton textile industries. Then foodstuffs industries. Then iron and steel production industries. Defense establishments. Services in hospitals, dispensaries, fire brigades, then India Government Ministry, India Security Press Services, copper mining industry, zinc mining industry, iron ore mining industry, services in any oil field, then services in the uranium industry, then pyrite mining, security paper mill, Hoshangabad, services in the bank, note press, then phosphorites mining, magnesite mining, etc., etc. These industries are coming under the public utility services. If any disputes are arisen in respect of these matters, it can be straight away brought to the permanent Lok Adalat, and the permanent Lok Adalat, considering the nature of the matters, can hear the parties concerned and dispose the same in an expeditious matter position. The public utility services facing certain problems in the current times, such as organization of these industries, their management, infrastructure, and pricing policy. As these industries produce on a large scale, it is difficult to tackle these problems. These are all the problems being faced by the permanent Lok Adalat. The government should provide aid to these industries and the maintenance of them. The Industrial Disputes Act 1947 is boosted in nature, outdated in nature now. Public utility services are of greater importance and current times. Therefore, the permanent Lok Adalats have been set up in all over the states, as I told you earlier. The public utility services are of greater importance in current times. A huge amount of investment is made in this sector, and the economy is greatly affected by these industries too. Therefore, it is deemed fit and proper to establish these permanent local adalas so as to give a speedier justice to the people concerned. There is much deviation in the condition of these industries from past few years. The working conditions and the industrial relations have also changed now to a greater extent. The evolution of new technology has led to an improvement of the quality of products, but also has led to the exploitation of consumers and workers. The recent amendments made in the Act, that is Industrial Dispute Act, has stressed on the importance of the public utility status, but there are more reforms which are essential. Then the government should provide infrastructure and management aid to these industries. To resolve the disputes between the industries need to be solved, and for this inquiry should be made about their working conditions. Therefore, the tribunals should be set up for dispute resolution. Labor codes should be made, and the guidelines should be given regarding the working conditions of workers. Now, then we can see the main features of Industrial Disputes Act are, because these are all essential to practice before the permanent Lok Adalat. The disputes will be resolved easily with the help of Industrial Disputes Act. The problem can be referred to the Industrial Tribunal and can be timely resolved by the appropriate government. There will be a check on the illegal lockouts and strikes. Fair terms and conditions will be made between the workmen and the employers. Then compensation and remedy will be given to the labor in case of his retrenchment or layoff. The main features of the public utility services are the it includes those goods and services which are indispensable part of human life, and without them it would be a great hardship for the human survive. The public utility services are mostly local in character and are regulated by the local government. These public utilities are organized as monopolies by the government as they provide basic necessities. So, any deficit in the quality of their product and services would lead to big social problems. Then public utility utilities involve huge investments. The entire investments had to be made prior to the commencement of the operations. There is significantly lower risk in the public utilities as there is no fear of change in demand and preferences of the customers. The demand and the supply of the goods of services and are hand in hand. Public utilities also achieve economics of scale as they produce on a large scale for a wide population. These are the public utility services are regulated under the Industrial Dispute Act. I told you already. It is the duty of these utilities to provide its services to all without any discrimination and at a reasonable price. It should indulge in unfair trade practice and should not hike the prices. It should provide goods and services at a fair rate and of good qualities to all. The Industrial Disputes Act ensures it for the protection of the consumers. The provisions regarding public utility status in the Industrial Disputes Act are the main purpose of the Industrial Disputes 1947 is to ensure fair term and conditions between the employer and the employee, the workman and as well as the employer. The Labour Ministry has extended the scope of public utility services and its status under the Industrial Disputes Act. It has extended it to the uh, speed services in the recent amendment of the Act 2010, which includes the processing, production or distribution of fuel, gases and industrial establishments manufacturing or providing nuclear fuel and components, heavy water and allied chemicals, and atomic energy and banking industry. These are all the categories classified under the public utility services. Then, how the permanent Lok Adalat is having the power to take cognizance of the cases. Any party to a dispute may, before the dispute is brought before any court, make an application to the permanent Lok Adalat for the settlement of dispute. No matter. Don't think that matter should be actually brought before the either tribunal or any court of law to make an application before the permanent Lok Adalat for pre-litigative scheme, provided the permanent Lok Adalat shall not have jurisdiction in respect of any matter relating to an offence not compoundable under any law. Provided further, the permanent Lok Adalat shall also not have jurisdiction in the matter where the value of the property in dispute exceeds 10 lakh rupees. Provided also that central government may, by notification, increase the limit of 1 crore rupees, that is the pecuniary jurisdiction. The limit can be extended, enlarged by the central government by way of issuance of a notification specified in the second proviso in consultation with the central authority. Central authority means National Legal Services Authority. After an application is made under subsection 1 to the permanent Lok Adalat, no party to that application shall invoke jurisdiction of any court in the same dispute. See, once the application is made under subsection 1 to the permanent Lok Adalat, no party to the dispute can make any application invoking the jurisdiction of other courts in the same dispute, where an application is being made to a permanent Lok Adalat under subsection 1 of section 19, the one amended by notification number SO 803E, New Delhi, dated 20 March 2015 of Ministry of Law and Justice, Government of India, shall direct each party to the application to file before it a written statement stating therein the facts and nature of dispute under the application, points or issues in such dispute, and grounds relied in support of or in opposition to such points or issues as the case may be, and such party may supplement such a statement with any document and other evidence which such party deems appropriate in proof of such facts and grounds, and shall send a copy of such a statement together with a copy of such document and other evidence, if any, to each of the parties to the application. Then the parties to the application may require to file an application, additional statement also before the permanent Lok Adalat at any stage of the conciliation proceedings. It shall communicate any document or statement received by it from any party to the application to the other party so as to enable that party to present reply thereto. When statement, additional statement and reply, if any, have been filed under subsection 3 to the satisfaction of the permanent Lok Adalat, it shall conduct conciliation proceedings between the parties to the application in such a manner and as it thinks appropriate, taking into account the circumstances of the dispute. The permanent Lok Adalat shall, during the time of conducting the conciliation proceedings under subsection 4, assist the parties in their attempt to reach an amicable settlement. That is the main principle, that the permanent Lok Adalat may assist the parties to reach an amicable settlement of the dispute in an independent and impartial manner. When a matter is being arrived at a settlement or compromise between the parties, the permanent Lok Adalat, the officers and other members who are presiding over the permanent Lok Adalat shall have to act in impartial manner. They shall not, they are not supposed to lean one side or the other side. It shall be the duty of every party to the application to cooperate in good faith with the permanent Lok Adalat in conciliation of the dispute relating to the application and to comply with the direction of the permanent Lok Adalat to produce evidence and other related documents before it. When a permanent Lok Adalat in the aforesaid conciliation proceedings is of opinion that there exist elements of settlement in such a proceedings which may be acceptable to the parties, it may formulate the terms of possible settlement of the 20 dispute and give to the parties concerned for their observations, and in case the parties reach at an agreement on the settlement of the dispute, they shall sign the settlement agreement and the permanent Lok Adalat shall pass an award in terms of their in terms of their and furnish a copy of the same to each of the parties concerned. Where the parties fail to reach an agreement under subsection 7, the permanent Lok Adalat shall, if the dispute does not relate to any offence, decide the dispute. Full stop. The procedure of permanent Lok Adalat, the permanent Lok Adalat shall, while conducting conciliation proceedings or deciding a dispute on merit under this act, be guided by the principles of natural justice. That is very important. While engaging a conciliation proceedings, the permanent Lok Adalat should be guided by the principles of natural justice, objectivity, fair play, equity, and other principles of justice, and shall not be bound by the Code of Civil Procedure 1908 and the Indian Evidence Act 1872. Then with reference to award of permanent Lok Adalat, as I told you, it is final as the award passed in the Lok Adalat. Every award of permanent Lok Adalat under this act made either on merit or in terms of settlement agreement shall be final and binding on all the parties concerned and on persons claiming under them. Secondly, every award of the permanent Lok Adalat under this act shall be deemed to be a decree of a civil court as that of the award passed in the matter of Lok Adalat. As per section 21, the award made by the permanent Lok Adalat under this act shall be by a majority of the person constituting the permanent Lok Adalat, because the chairpersons will be there. The chairperson can maybe district working or retired district judge. The other two persons will be accompanying the chairperson. The award passed may be on the basis of majority of opinion constituting the permanent Lok Adalat. And every award made by the permanent Lok Adalat under this act shall be final and shall not be called in question in any original suit. After receiving the award from the hands of the permanent Lok Adalat, that cannot be challenged by way of suit before a civil court. The permanent Lok Adalat may transmit any award made by it to a civil court having local jurisdiction for local jurisdiction, and such civil court can execute the orders passed by the permanent Lok Adalat as if it were a decree made by that court, only for the purpose of executing that award. The award can be transmitted to the civil court and not for any other purpose, particularly to challenge the award by way of suit before the civil court. The last time then the others, coming to our subject, the permanent Lok Adalat, vis-à-vis Lok Adalat, and the practice and procedure. So far, we have seen certain salient features of the Lok Adalat and its functioning, and the award which may be passed by the Lok Adalat. And on coming to the permanent Lok Adalat, the permanent Lok Adalat, how it is being set up in the states, and the awards passed by the permanent Lok Adalat, and accepting for the purpose of executing that award passed by the permanent Lok Adalat. That award passed by the permanent Lok Adalat cannot be challenged by way of suit in a civil court. Here, what is the difference between permanent Lok Adalat, the Lok Adalat, and permanent Lok Adalat? Then we have to differentiate the distinction between these two institutions. Number one, the permanent Lok Adalat is permanent in nature, but Lok Adalat is temporary in nature. Any party to a dispute may make an application to the permanent Lok Adalat for settlement of dispute before the dispute is being brought before the court. But in Lok Adalat, there is no such a condition like permanent Lok Adalat. The permanent Lok Adalat proposed to work on all working days, but the Lok Adalat held on Saturdays and Sunday, according to the convenience of the state authority or the Supreme Court Legal Services Committee, the High Court Legal Services Committee, and Taluk Legal Services Committee. According to their convenience, they can organize the Lok Adalat during the holidays, just like Saturday and Sunday. But in the case of permanent Lok Adalat, it is working in all working days. The permanent Lok Adalat is having jurisdiction over pre-litigation matter only. The permanent Lok Adalat is having jurisdiction only in respect of pre-litigation matters. But whereas in Lok Adalat, it is having jurisdiction over pending as well as pre-litigation matters. Even we have to see that if any supposing a borrower from a bank is not able to repay the loan amount before the concerned bank, what the banking authority will do? Normally, they will approach their panel lawyer and they request him to issue a notice, demand notice to the concerned the borrower. In this case, the borrower can directly approach the Lok Adalat. That is, actually without filing any suit before the court of law. That is litigative method. The borrower can approach the Lok Adalat by filing an application, a mere white paper with a writing about his grievances. Then the Lok Adalat will send a summons to the concerned banking authority, and they will come. The matter will be settled very easily without spending money, without suffering from spending time, and without wasting the court time also, and without any docket explosion. Nowadays, the cases are going on bulging before the court of law. You understand, when the judges as well as the presiding officers of the court are blinking. They do not know how to give a speedy disposal, even though they are trying to dispose the matter speedily, because the process, the several stages, even to attain a finality of a suit, the suit has to cross the several stages. First, you have to file plain along with the summons and other process. Then the summons have to be sent to the parties concerned. Then the defendants have to come to court, and they have to file written statement and additional written statements if any. Then and thereafter, issues have to be framed based on the pleadings of the parties concerned. Then the parties are directed to lead the evidences to support their cases. Then, like this, to attain a finality even in a civil suit, the suit has to travel several stages. But in this method, both in Lok Adalat as well as in the permanent Lok Adalat, we need not spend even a single pie. Even if any court fee is paid before during the time of filing a suit or case, after attaining settlement, after reaching a compromise, the court fee which is already paid by the parties have to be returned. That is the procedure. That is the benefit of the parties. The Article 39 capital A provides the parties concerned, the justice have to be taken to the doorsteps of the needy people. In search of justice, people are there. But now, even not only in civil suits and other matters, even in the common criminal offences also, the parties can avail the benefits of the Lok Adalat as well as the permanent Lok Adalat in respect of the public utility services. Now, the electricity tariffs, water tariff, understand. These are all in the rural areas also. In calculating the electricity tariff, so many problems are there. The consumers are facing so many problems. Therefore, they can very well approach the permanent Lok Adalat, which is being set up in their area, and avail the benefit of settling the matter by way of conciliation proceedings. Don't adopt adversarial methods. Don't go to court to multiply the burden of the court, because this is alternative dispute redressal forum. This is, as per the case of Salem Bar Association, the Civil Procedure Code has met certain amendments under Section 89 of CPC. Under Section 89 of CPC, it has been suggested the three ways. If a matter is brought before a court of law, prior to entry into the adversarial procedure, the judge or the presiding officer shall have to ask the parties whether they are ready to settle the matter before the Lok Adalat or conciliation proceedings or arbitration. If they are willing to settle the matter adopting these methods, better even at that stage, they can be advised to go to the advised to go and meet the parties to the suit to arrive at a conclusion to settlement. Even if they are willing to have the matter referred to the local adalat, the presiding officer can very well refer the matter to their. You understand? Therefore, the to make awareness to the people of rural areas, even in the urban areas also, the National Legal Services Authority, Supreme Court Legal Services Committee, High Court Legal Services Committee, and state legal services authorities are conducting so many programs, and our legal fraternities and the learner advocates are also participating in the awareness program in a large scale to take the scheme of the authorities concerned to the people and inviting them to come and settle their dispute, if any, before these alternative dispute resolution method. Don't adopt adversarial method and go to court to multiply their burden. And so far, I have been telling you, even if I am not able to please you, uh, please forgive me if I am boring you and understand. And I have made several things because out of for want of time. Still, I am having 10 minutes, I think so, up to 6:15. You understand? Then at this time, I would like to conclude my the program and this web seminar. And I necessarily once again thank Mr. Brother Om Prakash and Brother Murthy and other Mr. Vikas Chatterjee and other members. Thank you one and all. Thank you very much.
Yes. Mr. Murthy, you can unmute yourself.
Pardon?
And Mr. Murthy, so that questions which have been posted on the chat box.
Yes, Mr. Pardon me, voice is not clear, sir.
Now is it fine?
Sir, how I spoke on the subject, sir?
Fine, sir. Fine.
Thank you very much.
No. We have you have taken the entire differences and especially the end where you concluded that, and that is the entire reason. The few questions have been posted on the chat box. One question I will read and one question Mr. Murthy can take. Yes, Mr. Murthy. The first question you can take.
Yeah, first question. One second. How one Mr. Pradeep Kumar has asked, how the execution of the award passed by the Lok Adalat, is it as per CPC procedure?
Pardon, Murthy?
Yeah, the question is, one Mr. Pradeep Kumar asked, how the execution of the award passed by the Lok Adalat, is it as per CPC procedure? He's actually asking, I think, execution of the award passed by the Lok Adalat.
Yes.
What is the procedure? That's what I believe they is asking.
So that is the case decided by which court?
I will put it in my own words. It's a general question. He says that once there is a settlement arrived at between the local in the local adalat, yes, and the award is not being executed, or that award is not being implemented as such, then he says, what is the procedure? Do we go in terms of what is contemplated under, I can say, Order 21? What will be done?
Yes, to implement the award. Then we have to request make an application to the concerned local adalat to transmit the award to the concerned court from where the matter is brought before the local adalat for the purpose of executing the same. The award can be executed. Just like it can be treated as a decree of the passed by a competent civil court.
That's what he's saying.
Yeah.
As you had said that this Lok Adalat's award is as good as a decree. So he says that it will be executed in the same fashion and procedure what is contemplated in the CPC.
No. The Lok Adalat cannot have the power of execution. It can merely pass an award that can be executed by the civil court only, because by giving the same weight as a decree passed by a competent court of civil law.
So the answer would be once an award is passed, execution, the concerned jurisdictional court will have the power of execution, and if it has to be transmitted to some other court, the transmission order will have to be obtained from the local Adalat. Is it right, sir? Sir, you are muted.
So you will have to unmute yourself.
Sir, your mic
Sir,
is
unmute
muted,
yourself.
sir.
Unmute. That mic icon, just press on that. It will be unmuted.
Sir, your mic is muted. You have to unmute your mic, sir.
Sir, once we click on that, there will be an icon that you have to unmute yourself. Do that, it will be done automatically.
Yes, sir.
Are you able to hear me? Because my voice is, I'm not able to hear your voice clearly here in this laptop. That is the problem.
So next question is, can a Lok Adalat settlement order be used in a non-compoundable criminal case?
Honorable?
Under the criminal case, which is a non-compoundable offense, can there be a settlement in a criminal case?
Yes, yes. In the Lok Adalat, in respect of a criminal case of compoundable matter allowed. In respect of non-compoundable matter, there cannot be any settlement. Because the Lok Adalat doesn't have jurisdiction to take cognizance of a non-compoundable matter. Only in respect of compoundable matter, it can take cognizance.
In terms of section 320.
Yes.
Mr. Rivati, can a divorce or a restitution proceedings be settled in a Lok Adalat / permanent Lok Adalat?
Pardon?
Can a divorce or a restitution proceedings be settled in a Lok Adalat / permanent Lok Adalat?
I don't understand your question, sir.
Mr. Murthy, just read that.
Yes, sir. Sir, the question is whether a divorce or restitution proceedings settled in Lok Adalat.
Yes.
Yes.
Can be settled. In Lok Adalat, the matrimonial matter can be settled. No problem.
Yes.
It cannot be settled in permanent Lok Adalat.
Yes. So the question is twofold, sir. Lok Adalat or permanent Lok Adalat?
Permanent Lok Adalat is meant for the settlement of, public utility services alone. The matrimonial cases cannot be brought under the purview of public utility services. You understand?
Yes.
Any clear, sir?
Yes.
This is by Naveen. Please let us know whether the jurisdiction of the courts apply to the Lok Adalat. Can the Lok Adalat act beyond the jurisdiction of a particular case?
Well, I am not able to follow you because the voice is not clear.
Mr. Murthy?
Yes.
Yes.
I will put the question, sir.
Yes.
Can you hear me now, sir?
Yeah.
The question is one Naveen Kumar M has asked.
Naveen Kumar.
Yeah. Sir, please let us know whether the jurisdiction of the courts apply to the Lok Adalat.
Yes.
Can the Lok Adalat act beyond the jurisdiction of that particular case?
The Lok Adalat cannot travel beyond its jurisdiction. Lok Adalat cannot travel beyond its jurisdiction, and it can travel within its own boundary. It cannot stretch its hand over the other area. Yes.
Yes.
Yes. One question had come on the YouTube. It says that since the Lok Adalat is a permanent settlement and some parties want to slightly get the order modified, whether there will be a review or you will have to file under the writ jurisdiction.
To modify the order?
Yes, sir.
In the before the
once it has been settlement arrived, thereafter they realize that the award requires certain tweaking. So whether review would be permissible or they will have to challenge in a writ jurisdiction. How to go about it?
No, there is no need to challenge. If any matter it is rectifiable by the permanent Lok Adalat itself, by the chairperson or other members, the parties concerned can make an application very well before the permanent Lok Adalat to get the matter, corrected.
Meanwhile, he takes the question. I will just check it on the YouTube.
Yeah. Sir, one more question. I think it is out of syllabus. Pre-litigation be entertained by arbitrator or conciliation. So this may not be in this topic, I believe, sir.
In respect of matter pre-litigation.
Yeah, can pre-litigation be entertained by arbitration or conciliation?
Okay. If
that is
if there is a clause find a place in an agreement or consent paper, there an arbitrator can pass an award.
Yes, sir. Under the Arbitration Act, an arbitrator cannot act as a conciliator. Once he acts as a conciliator, then he cannot act as an arbitrator. Therefore, this is completely a different topic, sir.
Out of syllabus, I think.
Yes, it is out of syllabus. The next one is
the parties can take the matter to an arbitrator, provided there is a clause for that in their agreement.
Yes.
Right.
Yes, sir.
Otherwise, how the arbitrator? But even the award is passed, that can be taken to the court for execution. Yes.
Yes, sir. Yes, sir.
Otherwise, the other party will go under section 34 to set aside the award.
Yes.
Yes.
So it's fine. We have taken all the questions which have come on the platform, and it was quite an engaging session. The subtle difference between a permanent Lok Adalat and Lok Adalat was very nicely explained, because normally, as a common brush which comes to the mind is that the jurisdiction, the procedure is same. Probably wherever there is a permanency seat, it is a permanent Lok Adalat and Lok Adalat is normal. But very rightly said that it will be on a weekend, and permanent Lok Adalat will be in respect of primarily of the public utility services, and the jurisdiction regarding the money would be there. And so we had a session which was quite engaging, and we are thankful to Mr. K. Murthy and Mr. Om Prakash, senior advocate, who helped us to connect with a judge, coupled with the fact that he was very resourceful with his knowledge and the way he put the things across. And we are also thankful to Dr. Justice T. Mathivanan, who has taken us to the entire journey of the Lok Adalat and permanent Lok Adalat. As he said that we had given him a compressed time of 1 hour, but be that as it may, they said the good persons and the good persons can always execute things in the time given slot, and they can make you understand. And tomorrow, friends, we will have a session on remand, that is under section 657 and 167 of the Criminal Procedure Code. We have another resource person from Madras itself, Mr. Sundar Mohan Advocate, who is also a resource person in the National Judicial Academy. Do stay connected with us. Tomorrow again, we are with the knowledge partners of the legal studies, or also known as the Lex Studies. Thank you, everyone. Stay safe, stay blessed, and kindly keep on liking, sharing, and subscribing to the YouTube channel of the Lex Studies as well as Beyond Law CLC. Thank you.